So welcome to It's Your Money, Appealing Association Property Taxes. And for the next hour, I have the privilege of teaching you the ins and outs of property tax appeals for condo associations, homeowner associations, and multifamily. We're not going to touch so much on multifamily, so if any of you are here for multifamily, come and see me after. It's a little bit different. We'd be here for another hour after that. So I can feel the excitement in the air right now. Let me tell you, the feeling is completely mutual. When I was a little boy, I dreamed of speaking in front of a room of property managers about property taxes. So I'm living my dream, and I hope you are as well right now. So why are property taxes important for you as a property manager or as a board member? Well, you actually have a fiduciary duty to protect the interests of the owners and preserve the property value of the association. And one of the ways that you preserve the property value is by keeping property taxes as low as possible. Thus, it is imperative that a property manager or board member understand and comprehend the appeals process. Furthermore, as I'm sure many of you would attest, property taxes are an extremely hot topic, especially within the city of Chicago. And so it is very important for you as a board member or property manager to be educated enough to speak about it or know who to contact. So today I'm going to take you through the appeals process from start to finish, and hopefully you'll leave here a better property manager or board member. And like I said, there will be time for Q&A as well. So starting with property tax calculations, how are they calculated? Property taxes are calculated by taking the assessment times the equalization factor times the tax rate, which equals your tax bill. The assessment, or AV, is the partial property market value amount on which your property taxes are computed when applying the tax rate and equalization factor. So all property in Illinois is supposed to be assessed at 1/3 of market value. However, in Cook County, we use a classification system to determine the assessment level. And all residential property in Cook County is actually assessed at 10% of market value. That means if you have a $1 million home, the assessment would be $100,000. Or if you have a $50,000 assessment, the market value would be $500,000. The equalization factor applies only to property in Cook County. It is a number set by the Department of Revenue to ensure statewide fairness due to the classification system. The tax rate is set by the taxing districts and is based on the needs of the schools, public utilities, etc. This is the number that many of you do not realize, but is affecting your taxes so much and that you're actually getting upset with. So what can we control? We can control, or attempt to control, the assessment. When we are filing appeals, we are appealing the assessment of the property. We have no control over the equalization factor or the tax rate. They are separate from property assessment, and they are not determined by the assessor. They are not determined by the assessor. So how are assessments determined for a condominium association? Condominium assessments are determined for real estate tax purposes by developing a collective market value for the entire building and then applying the assessor's current level of assessment for residential property and a unit owner's percentage of ownership to the total market value of the building. The total market value is determined by analyzing sales that have occurred, typically within the last 3 years, and comparing how these sales relate to the values in the building. It is important to note that in Illinois, only real property is valued. It is also important to note that common area owned by the association and used for the benefit of the owners in the association should always be assessed at $1. Common area includes areas like the pool, the workout room, the package room, the lobby, and so on and so forth. Anything that the entire association is enjoying, a community room where you're going to have parties or your board meetings, those should all be assessed at $1. So then let's talk about the factors that impact the actual value. The percentage of ownership per each unit, the square foot area, the number of bedrooms and bathrooms, the age of the association in the unit, and the location of the unit within the building, the floor, the view. So those are all the things that impact the value. Moving on to the appeals process, this is where things will get a little bit trickier. So there are 102 counties in Illinois. Basically, there are two states in the state of Illinois. There is Cook County, and then there are the collar counties. So I'm going to try and work in where the collar counties differ. Like I said, or like I'm going to tell you right now actually, a lot of the collar counties have their own rules within as well. So Cook County is really the focus right now that I'm going to go through, but if anybody here has questions about the collar counties, we can answer those as well, and I will talk about the collars. So Cook County consists of 38 townships, which are divided into three groups. 38 townships divided into three groups: the city of Chicago, the north and northwest suburbs, and the south and southwest suburbs. Each one of those groups has a number of townships within it. So property is assessed every 3 years in Cook County on a triennial basis. Every 3 years on a triennial basis. So you see here the reassessment schedule for the city for Cook County. So you see the city of Chicago was last reassessed in tax year 2015. The next reassessment will be in tax year 2018. So if any of you are representing condo associations in the city of Chicago right now, I'm sure many of you are receiving fee agreements and bidding out property tax appeal work at this time. The north and northwest suburbs just were reassessed in tax year 2016, and in 2017 this year was the south and southwest suburbs. So the collar counties, on the other hand, are assessed every 4 years, or what is known as a quadrennial basis, and the next reassessment year will occur in tax year 2019. So now talking about the actual appeals process. The typical appeal begins at the assessor level. Okay? After assessment notices are published, and each township has a different publishing date, which actually is on the Cook County Assessor's website. You can see when your township is supposed to publish. We have 30 days to file our complaint after that date, and we have another 10 days to submit our data. Decisions typically take about 2 to 3 months after the time of the data being submitted. If we are unhappy with the result, we actually have an opportunity for something called re-review, where we can ask them, say, hey, we think you missed this, please take another look. It's important to note that at the assessor level, we actually do not have a hearing. It's just us submitting our evidence. Then we go to the next level of appeals, which will come later in the year, which is the Cook County Board of Review. The next level, at the Cook County Board of Review, actually consists of a 3-member elected board, and each commissioner is charged with representing a district within Cook County. So if you miss the appeal window at the Cook County Assessor, it's okay. You actually can still appeal directly to the Cook County Board of Review. So if your association failed to sign up or didn't know about the appeal deadline, you can still appeal to the Cook County Board of Review at the given time that they open for your township. If you are denied relief at the assessor level, or you received relief at the assessor level, but feel that the further relief is still warranted, you can file to the Board of Review. And once the board opens a particular township, you have 30 days to file the appeal. And they do it in phases. And then the second phase is the filing of data, and then they will open for actual oral hearings. They have a specific day that is designated for condos, where we go in and we talk about the condos. Decisions for the Board of Review typically take about 3 months, and once again we have an opportunity for re-review. Important to note, the assessor and the Board of Review make up what is called the administrative level of appeals. Okay? So after the Board of Review closes all 38 townships, and upon determination of the equalization factor and tax rate, the second installment tax bills will issue. In Cook County, tax bills are issued twice per year. We pay taxes 1 year in arrears, meaning that if the 2017 bill is due in 2018, the 2018 bill is due in 2019. The first installment bill, which comes out in February to March, is always based on 55% of the previous year's total. 55% of the previous year's total. If you want to figure out right now how much your bill is going to be in February, take a look at your total that you paid in 2016 and take 55%, and that will be your bill. The second installment bill is due in July, or issues in July and is due in August. That bill will reflect the savings that we achieve for you in our appeal. It doesn't actually say minus the savings, but it will be a lesser bill than it would have been but for our appeal. Other counties all have their own ways. For example, Lake County, and they'll send out one bill with 2 installment stubs attached, and taxes in the collar counties are typically due in June and September. But even though the tax bills have been finalized, we actually still have another opportunity to appeal. Okay? So you've paid the taxes, but there's still an opportunity for another appeal. There's 2 options: the Illinois Property Tax Appeal Board or the Circuit Court. I want to say it is not typical for a firm to go to either of these venues on behalf of a condo association, typically for numerous reasons, but one of the main reasons is that it's a very, very slow process. Right now we are working on cases from 2-3 years ago. And what happens is that there's a lot of sales within condo associations, and it's very hard to track down people who are in that association. There's also reasons because, for instance, the circuit court typically prefers to have an appraisal. A condo association is not going to go out and wanting to pay for an appraisal on behalf of the whole association. Circuit court cases are filed within 165 days from the second installment tax due date. Taxes must be paid within 60 days of the due date. That means if somebody didn't pay their taxes, they are out. Okay? There's also a filing fee there. One of the advantages of court, however, though, is that they cannot increase the assessment upon appeal. Now, I want to go back to the assessor and board review level for 1 second. It is uncommon for the assessor or board to raise taxes upon an appeal. We get asked that question all the time. If we file an appeal, are they going to raise our taxes? On the Cook County Assessor's website, it specifically says no. Okay? They really will not. If you provide a good case and good evidentiary data, they're not going to do it. So, especially with a condo association that represents so many people in one appeal. So, getting back to the advantage of court, at court will never appeal. They do not have the authority to increase your property taxes upon an appeal. But the disadvantage here is that the decision is based on clear and convincing evidence, and that's where typically an appraisal would come in. If we don't go to court, we could also go to the PTAB, or the Illinois Property Tax Appeal Board. The PTAB appeals must be filed within 30 days of the Board of Review's final decision. Here, however, as you see, assessments can be increased by the appeal board, so it's a very risky situation. So part of the reason we don't go to the appeal board is we don't want to get the condo association in a situation where they actually feel that the property is underassessed and they come back and raise it. That doesn't look good, okay? And then going to the circuit court, like I said, you typically need an appraisal, and it's also hard to track down the unit owners. Also in PTAB, there's the danger of interveners. In the collar counties especially, interveners are upset when the school districts are losing money, and they have the authority to come in as a third party to the appeal, and next thing you know, you have a 3-way fight going on between yourself, the intervener, and the county. So who can file an appeal? Who can file on behalf of an association? So important to know, 12 counties in Illinois actually consider representing a taxpayer the unauthorized practice of law. Okay? So Cook, DuPage, Kane, Lake, and Will are some of those counties, to name a few. That means I'm sure that many of you get letters in the mail from consulting firms saying, hey, we will represent you. Okay? Outside of Cook County, they're not even allowed to have the authority to do so. Okay? In Cook County, they can only file to the Cook County Assessor level. So, after the Cook County Assessor level, an attorney needs to take over. So always beware of who is filing on your behalf. You should always work with a licensed Illinois attorney. Okay? You may also represent yourself. You obviously have that authority. So good luck with that, but you do have the authority. So when is the proper time to begin the appeal process? The best time is the first year of a given triennial or a given quadrennial. So because typically they just raised it, and typically the relief that we achieve endures for all 3 or 4 years of that given triennial or quadrennial. So if we saved you $1,000, the association as a whole, $1,000, in essence, we saved $3,000 in a Cook County case, or $4,000 in an out-of-Cook County case. You can still file at any time during a given triennial or quadrennial. So if, for instance, your association missed that first year, or you just didn't know, or something was going on, you can still file in the second or third year. You can also file in the second or third year seeking relief above and beyond what you achieved in the first appeal of the first year. So, for instance, at Sarnoff and McCash, we are very aggressive, and we are always trying to appeal our clients' taxes on an annual basis. We review everything annually, and there's different market data, there's different sales, so it's always something that you want to be doing. And like I said, usually the worst they'll do is say no. So what are some common bases of property tax appeals for condo associations? Recent sales within the association. Like I said earlier, they typically consider sales that are about 3 years old. Even that's pushing it a little bit. Uniformity within the association. Vacancy. Perhaps it's a new association, a brand new association, and not all the units are sold yet. The condition of the association, maybe it's very old and needs a lot of work, deferred maintenance. And they'll also consider appraisals. What they don't consider, however, I'll tell you this right now, is a lot of people will call us and say, hey, there's a building next door and their taxes are a lot cheaper than ours. Why is that? Well, every piece of property is different, and they look at the property from within. They don't look at the property from the outside. The only time that they would actually ever consider another association is if it's an identical association, head to toe. Okay? So why does it matter if an association files as a whole versus each unit owner individually filing on their own? So real estate taxes on common interest properties reflect the value of the entire property. Therefore, it's beneficial to review assessments and taxes on behalf of the entire common interest association. In lay terms, it is a stronger appeal when everyone is involved. So what if one or more owners opt out of the appeal or don't want to be a part of it? Assessment relief still can be granted to the owners who participate in the appeal. It just gets more difficult as more owners opt out. It can also cause issues, and it's come up numerous times, when we have a larger condo association and, for instance, Unit 33J says they want to opt out. Well, what if 33J sells, we're not told about it, or we're informed, and it happens during the appeal process, or it hasn't shown up on the recorder of deeds site yet, and nobody told us about it, and the new buyer wanted to be a part of the appeal. Well, now they're left off the appeal because that unit has opted out. It's always better to try and get everybody involved. The board, the condo board, has the authority to sign up the entire association with an attorney with a 2/3 majority vote. Okay? That's an important fact to know. So you have the authority, as the board, to sign up the entire condo association for a property tax appeal with a 2/3 vote. Of the board. Right? The board, yeah. That's a good point. So what about exemptions, and how do they affect the appeal? There are many different exemptions available, and you guys should be aware of them because you should tell your unit owners about them. Property managers and board members should make unit owners aware of specifically the homeowner exemption. Every homeowner in Cook County is entitled to the homeowner exemption, as long as it is their principal place of residence. Okay? You also have to have lived in the home as of January 1st of the year in question. Okay? So if somebody buys this unit on October 30th, they did not live in the unit as of January 1st of the year in question. They will have to wait until the following year to get the homeowner exemption. The other two are the ones that I'm going to talk about. The senior citizen exemption. Anybody who's 65 years of age and uses the dwelling as their principal place of residence. is entitled to the senior exemption as well. Now is where things get a little bit hairy and where property managers get a little bit upset, is the senior freeze exemption. And what the senior freeze exemption does is it allows qualified senior citizens to freeze the equalized assessed value of their property for the year preceding the year in which they first apply and qualify. So the equalized assessed value, when we went to the tax calculations, when I said it's the assessment times the equalization factor times the tax rate, the equalized assessed value is the assessment times the equalizer. That equals your equalized assessed valuation, and then you bring in the tax rate after that. So it's freezing that number and keeping the taxes low. And so there's numerous qualifications for this, though. To qualify, you have to be born prior to, for this year, born prior to or on in 1952. You also have to have a total gross household income of no more than $55,000. Also, you have to own the property or have a legal equitable leasehold interest in the property on January 1st, 2016 and January 1st, 2017. I can give you all this stuff, and it's all available, by the way, on the Cook County Assessor's website at cookcountyassessor.com, and it will explain every single exemption. So what if a unit owner, and I'm sure that many of you have dealt with this, what if a unit owner says, hey, I don't want to participate in the appeal, I have the senior freeze exemption? Well, this is what you're going to tell them. You're going to say, you do want to participate in the appeal. It does not hurt their exemption, okay? It preserves the marketability of the unit. Because if that assessment isn't being changed because that person decided that they just want to keep it at their frozen level, when somebody goes to buy it, that senior freeze exemption is gone, okay? And now they're going to have a unit that has a much higher assessment. So you're preserving the marketability. It also preserves the uniformity of assessment with units that are not subject to the exemption. So how can you get around it? Many firms don't charge the unit owner who has the exemption. Keep them in the appeal, request your attorney to say, hey, just don't charge for the senior freeze exempted unit. Okay? They're much better off, and it's helpful to everybody. So, how can a property manager assist the attorney in the appeal process? Okay? You are a team with us. Our information comes from you. One, you can provide the most recent percentage of ownership from the most recent amendment to the condo decks. We need that to determine the percentage of ownership. You can inform your attorney of any common area space. Let us know if there's a lobby or a pool or parking or package room, community room that needs to be assessed as $1. We've actually had scenarios where we've had to go in and have file certificates of error. It's a whole other issue, but file certificates of error to get that changed because the condo association was being charged as if it's a full unit and getting a full assessment. That $1 is a big deal. It should only be assessed at $1. You should also advise the attorney of any commercial space in the association and confirm that if that unit wants to be a part of the appeal. A lot of times there's a commercial condo at the bottom, so always find out if that unit wants to be part of the appeal, because oftentimes they leave it out, and then that unit somehow calls us and says, hey, I thought you filed an appeal, and why didn't I get relief or whatever, and we say we're not told. So you can also let the attorney know if there are blocks of units that are used as rentals. Perhaps an investor came in and bought 7 or more units for their own purposes, and they rent them out. Well, those units should be assessed differently than the condo units, okay? You can also notify the attorney of any deferred maintenance. Was there a fire? Was there flooding? Does the HVAC go out and you need everybody to move out? Something. Any deferred maintenance. All this stuff that's negative helps for an appeal, okay? Let the attorney know of any senior freezes. Provide any recent sales that you're aware of, and let the attorney know if there's any sales that are any units that are under contract. Okay? And also, like I said earlier, remind the unit owners that opted out in the past that they may want to be included in the future appeal. Go back and do it. Alright. So now, let's move on to the favorite part, the fee agreement. Okay? So, many firms charge differently on condo association appeals. Okay? The typical fee structure is based upon a percentage of the first year's savings. Okay? Therefore, if an attorney is charging 1/3 of the first year's savings, the entire bill would be charged up front, and that savings would likely endure for the remaining years of the assessment period. So if Sarnoff and Bikash is appealing, and I'm just using the 1/3 as an example, if Sarnoff and Bikash is appealing your association and we saved you $1,000, your bill would be $333, but in essence the association saved $3,000 because the savings for that assessment will have endured. We will still attempt to go back in years 2 and 3 and get further relief above and beyond that which we got in our first year, and we would only charge based on that new savings only. So it's very important for you to understand how you are being charged as an association, okay? Because some things can get a little bit hairy and tricky. Sometimes some attorneys will make their fee look less by saying, hey, we're only charging you 10% of the annual fee, of the annual savings. Well, if you have one fee agreement in front of you that says, hey, we're charging you 20% of the first year's savings, and then somebody else comes in and says, hey, we're going to only charge you 10% of the annual savings, well, that 10% is actually 30%, because they are charging you 10% per year of the savings that they achieved for you. And then in each year, they're using the tax rate and equalization factor from that year for the bill. So your bill is actually increasing, so it's not a good way to do it. But everybody has their preferences, but like I said, be on the lookout for language that can be tricky. You may want to ask for a cap on your fee, okay? So that way, the association knows what their total exposure might be. So it could be a percentage with a cap. Hey, we're going to charge you 25% with a cap on fees of $12,000 or $5,000 or whatnot, depending on the size of the association. Some firms may not agree to a cap, some may. There's also some firms that charge on a flat fee. I do not personally agree with this form, because if you're being charged on a flat fee and you're saying, hey, we're going to be charged $5,000 per year, well, in years 2 and 3 there might not even be anything to do, and you're just paying for nothing. So you can still appeal, but no relief might be granted, and so the flat fee is not exactly the best way either. My preferred way is, like I said, the very first thing is a percentage basis on the first year's savings, and then hoping that the attorney will keep reviewing each year of a triennial or quadrennial. Okay, and finally, we're going to talk about the bills. So typically, an association will receive one bill, which delineates the savings per unit, and then has a total number. The association will then send one check on behalf of the association, which usually comes out of the common funds, or if you want to charge it back to each unit owner, you can collect it from within. Most firms are not willing to accept a check from the person who lives in 2E and 2F, and going after it is up to the association really to bring in the fees and then pay the attorney accordingly. It's also important to note that the bill does not include the exemptions. We don't charge you for the exemptions that you were receiving. So our fees are structured based on the amount of savings that we achieved for you, and then any exemptions you got would come off that on your own. And then also finally, typically the association is billed based upon the most recently ascertainable equalization factor and tax rate. So if we were to wait until the actual tax rate was known, you would not get your bill for a very long time, okay? Because we might be appealing something at the beginning of the year or at the end of the year, and we don't find out the taxes, the actual tax rate, until almost a year later. Associations are like, hey, what's this bill all about? So we bill typically on the most recently ascertainable tax rate and equalization factor, which actually comes out to the benefit of the association, because typically the tax rate and or equalization factor is higher than where it was in the previous year. And that, ladies and gentlemen, is hopefully the most exciting hour of your week. Half hour of your week.